Moving on to item number 4, the public hearing for appeal number 2-2018, Martha Baracker Construction. Appeal a matter concerning enforcement of the 2009 Virginia Unified Statewide Building Code. The property involved is located at 1255 Pilgrims Way, Bentonville, Virginia 22610. Before I get started, I need to read a conflict of interest disclosure statement. On item number 4 on today's agenda, public hearing appeal number 2-2018, Martha Baracker Construction. Need to disclose the following. There's an officer or employee who has a personal interest in the transaction as defined by the Virginia Code 2.2-3112A, pursuant to Virginia Code 2.2-3115F, and disclosing that Dave Baracker is employed by Martha T. Baracker, DBA Baracker Construction, located at 2594 Stonewall Jackson Highway, Bentonville, Virginia 22610, which is the appellant on today's agenda regarding construction of a home located at 1255 Pilgrims Way in Bentonville, Virginia, permit number 493-2015. The transaction has application solely to property or a business or governmental agency in which I have personal interest. According, I must disqualify myself from participating in this matter before the local Board of Code and Appeals. I ask that the disclosure be made part of the minutes. Dave Burke.
No objection?
Motion. Do we need to do a motion?
Yeah.
All right, getting ready just to give you a little brief of how this works is we'll ask the appellant to come forward, be a 15-minute time limit or within reason.
Point of order, Mr. Chairman. Since you have also performed work with Baracker Construction and have currently put in a bid to fix a prior notice of violation, I request that you recuse or disqualify yourself from this hearing. Mr. Carr.
You want to address that? I think you covered it the last time.
I thought so.
Yeah. You're not privy to the contract. You're a subcontractor, but not privy to this contract.
He is privy to the previous notice of violations, which he has put in a formal bid to fix, so he has been provided interest in this case.
I don't know how your bid on previous notice violations is adverse to any interest in here. In fact, it would be to the benefit of Ms. Atwood because you're doing work for her being paid by these folks, possibly, potentially. Your interests are split evenly among everyone. And the fact that you're weighing notice of violations, in the first case you acknowledge that there are violations, and in this case, you are now considering notice of various violations in the notice, and it seems to me that you can be even-handed. Just my thoughts.
I agree.
I agree. We'll continue on. Then I'll give Mr. Bean 15 minutes. Then there'll be a rebuttal by the appellant, and then a rebuttal by the building department, and then a rebuttal again by the appellant. Those will be 10 minutes. There'll be a question and answer session for the appellant and the Board of Code Appeals, and then a question and answer session for the Warren County Building Official, David Bean, and the Code Appeals Board. So at this time, we'll go ahead and get started with the presentation from Martha Baracker and Baracker Construction for her representative.
name is Joel Francis with law firm of Bike and Rose for the appellant, Martha Baracker and Baracker Construction. I just have here copies of the notice of violation. I've numbered the 12 violations just so it's easier to discuss them in the argument. We can refer by numbers instead of this picture on this page. My understanding that the nature of this appeal derives from the notice of violation that I just handed you, but it also goes back a few months to an appeal that originated from Ms. Atwood 14 months after final inspection and certificate of occupancy were issued by the county. Various alleged code violations were brought to this board's attention by an appeal, again, that was 14 months after she had moved into the house on the authorization of the county. And the alleged violations were not brought to this board's attention by any licensed or by a building code official employed by the county. It was brought to this board's attention by a different licensed home inspector, someone who was licensed by the Department of Professional Occupational Regulation, but not anybody authorized by Warren County to issue code violations. So to that extent, we would just generally object to the nature of any of these appeals because I don't believe that the appeal is properly before this board, as the origin of all of these appeals were brought in an unorthodox manner that doesn't necessarily jive with the building code. The building code requires an appeal to be made to the board after violations have been cited by a building official. And her appeal did not state whether she was appealing the results of the final home inspection. It did not state whether she was appealing the issuance of the certificate of occupancy. It was just alleged code violations that were discovered by her licensed home inspector, but not by a building official who was allowed to issue notices of violation. So just from that foundational perspective, I just state for the record our general objection to this string of appeals that has brought us here today. On to today's matter, the notice of violation that was issued by the county on June 13, 2018. The building code section 115.2, notice of violations, it says that the building official shall issue written notice of violation to the responsible party if any violations of this code or any directives or orders of the building official have not been corrected or complied with in reasonable time. The notice shall reference, this is the important language, the notice shall reference the code section upon which the notice is based and direct the discontinuance and abatement of the violation or the compliance with such directive or order. I point out to you that code section because it specifically and explicitly requires that each violation be joined with a specific code citation. That way all of the violations are measured by an objective standard, not by contractors such as yourselves who may have opinions or thoughts on what good and proper workmanship should be. It all goes on an objective standard based upon the Uniform Statewide Building Code. Numbers two, in the copies that I provided you, numbers 2, 5, 8, 9, and 11 were all issued without any reference to a Uniform Statewide Building Code section. So from that starting point, we ask that all of those be dismissed because they are not properly before this board. They are in violation of section 115.2 of the Uniform Statewide Building Code because they do not cite a code section associated with the violation. There's no code authority backing those violations, and they are not properly for this board's consideration today. So we ask that all of those be dismissed. The second issue we have with those specific ones as well is that the language says that the board feels that there is a violation there. However, the Uniform Statewide Building Code does not authorize this board to issue violations. If you look in the sections dealing with the authority of the local board of building appeals, starting in section 119.1 of the Uniform Statewide Building Code, the appeals board is simply that. It's a board that listens to appeals made by contractors or construction workers or builders in the community, appealing code violations brought before the appellant's attention when the building code official and the building inspector identifies a problem on the job. The board is a third-party neutral between the building code official and between the appellant. The board does not have the authority under the Uniform Statewide Building Code to issue its own violations. That's the job and the responsibility of the county building official. So again, for those that numbers 2, 5, 8, 9, and 11, which you notice are 5 out of the 12 in the notice of violation before you, again, I would argue that they are void because they are not properly before this board, as the board did not have the authority to issue those violations. They did not come from the building official. And then if you'll just walk with me through the balance of the violations, numbered according to the document that I provided you. And bear with me as I will rely upon the appellant to provide some technical supplements to my argument here, as they are the experts in the field. Violation number 1 on page 1, referring to the bracing. Section 115.2 of the Uniform Statewide Building Code says that the notice has to cite the code that we've been through before, and it must direct the discontinuance and abatement of the violations or compliance with such directive or order. So in all of these notices, we're looking for some order to, or some direction to abate or discontinue the violation. Number 1, it says that it cites generally to the statewide building code and that specific section, but it does not give any direction or order to abate a violation. It merely says that diagonal bracing is recommended. It doesn't specifically state what the violation is. It does not provide any order in that violation to fix anything, or, again, I would argue that it would be, in kind of criminal law terms, void for vagueness, because a person reading this, looking at that notice, it's not clear exactly what the order is, or what the direction is, or what the violation is, because it just says that diagonal bracing is recommended. Again, this is not a matter of workmanship or professionalism. It's a matter of objective standards codified in the Uniform Statewide Building Code. In number 2, again, there's no USPC citation. We would argue that it's void for that reason, and I believe before you have the nature of my client's appeal, which explains the more technical issue behind number 2, in that the fasteners or adhesive are not required by the code. Is that correct, Mr. Racker? Should be number,
Oh, yeah.
number 2 with the joist hangers.
Yes, it's not required.
In number 3, the notice says that the design size of this beam should be confirmed by a registered design professional. The issue there being, is it a violation or not? Are we still waiting on a third party's opinion to know whether there is a violation present with that beam? We also had the issue raised in the document that my client provided you with the appeal, that work was done after the fact, after the final home inspection, beyond when the building code official would be issuing notice as a violation. The same can be said for number 4. Number 5 is missing a USBC citation, therefore it is void according to the USBC. Number 6, the notice says the siding and trim installation problems, but it does not tell us what those problems are. It does not give, according to the code, direction or an order to discontinue or abate the violation. It does not state what the violation is. It simply says that there are problems. Again, any appellant reading this would not have the notice necessary to fix the issue. Number 7 cites to a general table included in the statewide building code. Client asserts that those railings that are identified in that picture are not guards as defined by the Uniform Statewide Building Code. They're merely decorative. And they do not need to withstand the force of 50 pounds or 200 pounds identified in that notice to meet code, because the elevation there, and you can see it in the 2 pictures below, it's all the same area of that front porch. Perhaps the picture in number 9 gives the best illustration of what we're talking about here. The code requires that the guards that are capable of withstanding the 50 to 200 pounds of force be installed when the elevation is 30 inches or above. According to my client, that elevation there identified in number 9, number 7 is just a close-up picture of that, is not 30 inches. The code does not contemplate those handrails being guards under the code's definition. They're merely decorations. I also believe that Mr. Buracker has a comment regarding the type of fasteners that were used for those posts, and that they were consistent with manufacturer specifications. Is that correct?
Yes, they're Timberlock screws.
Timberlock
They were approved by the county and through the IRC.
Were you all able to hear him? Okay. Number 8, I'll just repeat again for the record, there is no USBC citation in violation of section 115.2 of the Uniform Statewide Building Code. And the same goes for number 9. I'll come back to number 10, as that one's a bit more technical, and I'll rely on my clients to provide more background with that notice. Number 11 is lacking a USBC citation. And number 12, there are 2 issues with number 12. One is the area in the garage falls underneath the draft stopping threshold. The threshold, I believe, kicks in at 1,000 square feet pursuant to the statewide building code. The garage, I believe, is approximately 600 square feet. Second, the open void there with access panel or whatever you want to call it, simply replacing that cures the alleged violation. This takes us back to the issue of this whole appeal in general, is that this appeal was brought originally by the homeowner 14 months after certificate of occupancy and final home inspection. That panel could have been removed within those 14 months. There's no evidence otherwise to say that it wasn't. So to come back now, long after final inspection and certificate of occupancy were issued, and call that a violation without any evidence that it's been empty or open for 14 months, calls into question the legitimacy of the actual violation. Going back to number 10, my understanding is that the chimney was purchased from a retailer, and that the chimney and the fireplace meet all manufacturer specifications. That the chimney is rated and properly equipped to fit the fireplace, and so the notice says that the chimney system does not match the fireplace, but is made by a different manufacturer. My understanding of the code is that they're allowed to be made by different manufacturers. They just have to be rated to fit each other per manufacturer specifications. All the pictures of the chimneys in other locations show the manufacturer's labels on the fireplace and the chimney, and that they all fit together accordingly. If you would all like to add.
Yes, I've got from the owner's manual the components for the chimney, and you can tell by the picture. I'm not sure if on this one, but on the first violation, it shows the pipe series number, and this is an email from the distributor that we bought it from, and he references a page number of the owner's manual, and I printed that.
I'd like to call a point of order. Since I am the property owner, I deserve to get the same information as the plaintiff and the appellant.
Do you have a copy?
Yeah.
When the board is satisfied, please take your time. I'll just kind of wrap up with closing remarks. I will state just in good faith that the appellant has attempted to remedy some of these issues and alleged violations before this matter ever coming to this board. The property owner has not provided access to the appellant to accommodate the access issue and being permitted access to the property to make whatever repairs are necessary on an outstanding punch list or for these alleged violations. My client has also offered to foot cash and have another party come in and remedy any violations, and has not been afforded cooperation from the property owner. And so, some of these matters may have been cured before we ever came to this spot. The parties have just not been able to come together to work that out. One of the reasons I highlight the issues of these notices is because in general legal standards, due process, which you've heard in the Constitution, which you hear on court TV all the time, or whatever, due process has been defined in courts all across the country, including the United States Supreme Court, as notice and an opportunity to be heard. And so I hammer down on some of these notices because they don't provide notice. And as I've illustrated, if a contractor receives a notice of violation and they look at it and they can't tell what they're supposed to do to fix the violations, there are serious due process issues implicated in those situations, especially considering those notices that didn't even include a code citation. We have to question whether the contractor has been afforded due process under the law, whether it's under administrative law like the statewide building code, or if we get up to the level where this appears before a circuit court, whether it's the law of the Commonwealth of Virginia. The opportunity to be heard is easy. Here we are today. But as I pointed out to you, some of these things we have struggled to find the grounds to address them because we're left wondering what the actual notice is. What are we supposed to come here and address because the notice doesn't afford us the information necessary to address those, and thus our opportunity to be heard could be considered weakened as well. And so while it may seem like it's just another issue of building code violations, there are some deeper issues here that implicate general principles of the law that need to be considered because, my client is a contractor who's trying to get the job done. They're trying to build homes for people and put people in their homes in a timely process and finish the contract and move on to the next. And as all of you have experience in the trade, I'm sure you can understand that these types of issues can cause a serious holdup and cause extreme financial problems for contractors who have to continuously come back to appeals that may very well never should have been brought in the first place. So with that, I appreciate your time, and we await the building inspector's comments and our opportunity for rebuttal. Thank you.
Good afternoon, members of the board. The appeal that you have in front of you this afternoon is solely based on the determination from the last appeal that was heard. These items are the items that were cited by the board, this board, that they felt were code violations. During that appeal, the code sections were never discussed, they were never rectified, they were never brought up. The hearings, as far as for the local board of appeals, it states that decisions of the LBBCA, which is you, shall be final with no further appeal, if no further appeal is made, I have two options. I can either enforce the findings of this board, or I can appeal that decision. In this particular case, I felt that you were very straightforward, that you felt that these were code violations, so I pursued with another notice of violation. As the appellate's representative said, the notice of violation has to be issued by the building official. There's no give and take on that. It says specifically, notices of violation. The building official shall issue a notice of violation to the responsible party. That's what I did. That's not a decision or an ability by this board to be done. Yours is only to decide as far as whether the decision that I've made prior to that is valid and just and with the full intent of the code. Issuing the notice of violation brings us back into another circle for the simple fact that the appellate of the hearing today has full and legal right to appeal that. Some of the items they've said, as far as the code sections not being there, I agree that I could not find anything. Unfortunately, I was not provided anything to go on that. But as the code specifically says, the decision of your choosing is what needs to go forward if it's not appealed. I will stand on that as far as this goes. I'll be prepared to answer any questions that you have when the appropriate time comes up.
Board's indulgence, I'll be brief. I appreciate the building official's remarks that he was abiding by his duties as instructed by this board. I would just redirect you to my previous argument. The code says what it says, that the notices must include citations to the building code. 5 of those 7 do not, and I've already called into question the legitimacy of the other 7 notices on the grounds that I do not believe they provide proper notice. And I also call into question the board's authority to identify code violations. Let me think about how to say this. I call into question the board's authority to take violations that are brought before them not by a building official and then direct the building official to issue notice of violations based on those. Because the board, again, is in the position of a third-party neutral and are only there to weigh violations that are reported to the board by the building official, not by someone who's not employed by the county. And I understand this board directed the building official to issue this notice of violation, and for sake of, to avoid repeating myself, this notice of violation has its ailments, which I've identified already.
David, did you have anything?
I'll stand on what I've said previously.
Ms. Barker, did you have anything else?
You have a copy of the trust details that were identified in item number 1. It clearly shows that there's no diagonal bracing required. I want to make sure you have that. I feel we've addressed everything. I've got a punch list of items when we did the walkthrough with the homeowner, and we took care of every punch list item with the exception of 2, which she has not allowed us to complete. And it's just snowballed from that point with items coming up, and it's just been a very frustrating process for us. And Mr. Hatcher, I had noticed, had made a comment in the first hearing that why didn't the homeowner hold back money from the contractor until things were done? And in fact, the homeowner still holds $8,000
Okay.
Point of order, I would like to speak as the homeowner.
Okay.
The reason that Baracker Construction LLC, who I was in contract with, has not been allowed to return to my home is because Baracker Construction LLC is not a licensed contractor in the state of Virginia. Martha T. Baracker / Baracker Construction has a personal contractor's license. And only until recently, in June or July of 2018, did she even obtain a Warren County building permit. So by me letting someone on my property that did not have a license, I was aiding and abetting in the commission of a crime if I did that. They were not allowed to come back because under my legal counsel, I was not to let them come back.
Okay, we'll start our question and answer session. You guys have any questions?
Mr. Green, what the young lady just said, is that a fact?
Is what?
That the contractor doesn't have a license? As far as you know.
The building permit was issued to Baracker Construction.
Point of order, the applying,
Can we get,
Well,
let's
yeah,
get to it and I'll give you your opportunity, okay? Let's, one at a time, please.
Okay, the permit was issued to Company A. Was Company A the actual contractor, as far as you know?
The building permit was issued. We have no legal authority or right to require a copy of a contract.
Okay, well, the person of interest down there is asserting that the contractor legal entity different from the one to whom you issued the permit actually did the work. And I'm trying to figure out if that's a fact.
That I would not be able to answer because, again, I don't have the ability
Okay.
to.
Counselor, would you know the answer to that question?
Respectfully, I would object to any inquiry into that matter because it is not an issue that's before this board. The issue before this board is the notice of violation and whether those notices are sufficient or not. And so I would object to that inquiry because, again, it's not the issue that's before this board.
Well, I think your client raised it by saying that, they haven't been paid.
Our client also said that they are willing to work things out and not bring this matter before the board, and that doesn't require any license either.
Okay. While you're up there, I have a question for you.
Yes, sir.
Do you believe that building inspectors are always infallible?
I believe that all humans are prone to error.
Okay, so if a citizen believes that a building official has made a mistake, not necessarily saying that Mr. Green has, but if a citizen believes they have made a mistake, what remedy, what would be the mechanism to address that? Because you say it's illegitimate to address it through this board, if I understood you correctly.
Well, let me rephrase. I think there are grounds to make those issues and bring them before the board. I'm focusing on the procedural aspect, that things were not done according to the proper procedure. The initial appeal, to my knowledge, was brought just saying that there were violations, alleged violations identified by an independent home inspector. They were not brought to a building official's attention. They were brought immediately before this board. The building official only issued the violations after this board decided that there were violations. And the appeal was never phrased that the final inspection was in error. That statement was never made in the appeal documents. And so I just pointed that out to question that the procedure was done properly.
I believe the inspector's report was given to the building inspector's department before it came to the board, because building inspecting department did issue a couple sites of violation
Okay,
prior to the board
okay,
meeting. So you're in there or there.
okay, well, I'll acknowledge that. I'm going off to the best of my knowledge.
Well, I wasn't satisfied, and, you know, keep it simple for a layman. You made a big point about the due process, and all I wanted to know was, if a citizen believes the building inspector made a mistake, what would be their remedy to address that? This particular person brought it to this board, and you said, we're not authorized to deal with that problem. What would you suggest would be the due process for a citizen?
My understanding of the procedure, though, would be brought before the building official first, and then brought to this board if the building official did not make the findings of violation, or that the homeowner would actually challenge the finding of the building official that that the final inspection was accurate, and challenge the inspection itself.
I think that's kind of what she did.
Okay.
I have no other question.
May I speak?
Yes,
Okay, you asked if it was, okay, here is the United States Building Code 108.4. Prerequisites to obtaining a permit. In accordance to 54.11111, the Code of Virginia, any person applying to the building department for construction, removal, or improvement of any structure shall furnish prior to issuance of a permit either satisfactory proof to the building official that he is duly licensed or certified under the terms of Chapter 11, which is Section 54.1-1000 in sequence of Title 54.1 of the Code of Virginia, to carry out or superintend the same or file a written statement supported by the affidavit that he is not subject to licensure or certification as a contractor or subcontractor, so on and so on. That has to be given to the building official prior to getting a permit. Okay, any person applied on the application submitted by Martha Buracker to the building official, the name of the applicant was listed as Buracker Construction LLC. So by Mr. Bean giving them a building permit, that is a Class 3 misdemeanor. After that, what they did is they took the name LLC and they transferred it, which is also a big no-no, because licenses are issued, this is Virginia Code, to firms as defined in this chapter and are not transferable. So basically, he gave an unlicensed entity access to rebuild my house, and my house has turned into a big, huge mountain of a mess, and now I'm stuck left holding the bill because I don't qualify for the transaction recovery fund. Their attorney is incorrect. I started going to Mr. Bean in November of 2017 after dealing with Buracker Construction up until the point D-Corps found that they were not licensed because I did not know it. That is when my attorney said they can no longer be on my property, so they have not been back on my property. I then went to Mr. Bean. I've given him everything that y'all have. You saw on the list where he put cosmetic, code, cosmetic, not code. Y'all had a copy of that. I went to him. He came out there, he looked at a couple things trying to pacify me. So then I came to you guys. I'm very happy with what I got from you guys, but it still doesn't address that he gave an unlicensed entity a permit. How many others of those are floating around Warren County? Buracker Construction LLC hasn't had a permit or hasn't had a license since they were formed in 2002. And they had a Buracker Construction, well, they just got their business license in the last month. So here I'm stuck left holding the bag while the government official is just like, oh well, let's just see how it goes. This has got to be stopped. And I have went to the State Technical Review Board, and they are coming out for a fact-finding conference on either August the 13th or August 16th. Because if Mr. Bean didn't like what you guys said, he should have appealed it. I liked what you guys said, but I wanted more, so I still appealed it. So they're coming out. They think I have a valid complaint.
Let me make one comment. I've let everybody say their piece. I don't want it to get out of hand, so I kind of like to keep it to the items at hand, the 12 violations or this appeal versus listening to all the other stuff. If we could just kind of tame it down and let's move forward, sure would be nice. Dan, did you get there? Any questions?
Yeah. Mr. B?
Yes.
You specifically said that items 2, 5, 8, 9, and 11, which the board cited, you could not find a code reference that would address those things?
Correct.
Did you look at R301.1, which is the general structural integrity paragraph? Sorry to put you on the spot here.
R301.1?
Yes, sir.
Yes, sir, I did.
And with regard to load path?
You have to go back to the administrative section,
Okay.
and it tells you that anything that's required by the building code needs to meet this code. If it's not required by the building code, it does not need to meet the intent.
Can you go further? Help me understand that. So,
You can have items within a structure. If they are not required, they don't need to be meeting the code for the building code. The code is the minimum. That means if it's required by the code, it has to meet the code. If it's not required by the code, it does not need to meet the code.
so specifically, let's just go to a hopefully simple one. Item 8 on today's agenda.
Yes.
So it says the steps are pulling away. There's no code reference that says,
That's a workmanship. It's still there, it's still holding, and it held the load.
It doesn't require a footing under those structures.
No, it does not.
You can sit on the dirt.
Yes. There's no code section that cites a foundation is required under there.
so just to second that, there is no requirement for a stoop or a stair down the footing.
No. If you can find that in code, let me know.
How about
Because it is not there.
the porch itself? Does it need a foundation?
Porch,
Porch itself?
which porch?
The porch that the steps are coming off of.
That is foundation, yes. That post that's right beside there,
Is not the steps part of the step,
no,
porch?
no.
I think so.
Steps are defined separately from a porch.
Yeah.
To follow the same vein then, I think I know your answer, but let's go back to the guardrail issue. Item 7. No, that was an issue that you had cited apparently, that the guardrail, apparent guardrail.
That's because I could find and cite an actual code for that.
But it's not required,
It is not required at that location.
so why does the code apply then?
The code applies to the side of the house.
Sorry, I missed it.
Part of this does require a guard. Part of it does not. The part that was depicted in all the pictures that cited that the guards were not properly affixed,
Right,
were not affixed because they were not guards.
okay.
The code does not actually talk how it has to be fastened. Mr. Hatcher brought up previously in the last appeal that he felt that it should have gone through the deck down to it. There's no code section that says that it needs to go through the deck to be fastened. It needs to meet the poundage.
Right.
The poundage is
I
met
understand.
by what's there.
And how was that evaluation made?
That's an evaluation that we've made on every single deck in Warren County since I've been here since 2004, by pushing against it with a strong force. Now, if somebody has a test that they would like to perform on it to make sure that it meets that, I'll accept that test. But that's the test that we have done since 2004, and we have yet to have a guardrail fail.
Help me understand again your explanation of the proceeding to cite these as violations without our code, without a code reference in our last meeting.
Based on the 119.5 that says your decision will be final unless it's appealed.
So, essentially against your better judgment, you...
I can't determine your process. I can only take what you tell me that I've misinterpreted
Okay.
and apply that.
I have more questions about Poland, so that's fine. Yeah.
Item 11, is there not a code requirement that all masonry chimneys and prefabricated chimneys have at least a 2-inch minimum clearance?
The 2-inch minimum clearance?
Yes, up against wood, up between wood surface.
That's on the first
Is
NOV.
that not, is there not a code for that?
Yes, and that was cited.
Okay, he's objecting to this, says it's not required.
That's the first NOV, that's not this one.
The number 11,
Yes.
that's the only information that was provided there. And if you look at the last part of it, it says fiberglass insulation.
Well, this says between the fireplace chimney and the roof framing.
And the last part, and fiberglass insulation.
Yes.
That's what the citing is. I assume, because that's the only violation I can see.
Well, it is a violation, is what I'm saying.
That's why it was cited, and that was why we placed it the first time.
Well, he's listening steadily. He's disagreeing.
Then he disagrees. I will state
I disagree with
I
him.
will state one thing, that if you look, at the picture that is in number 5,
Okay?
that is the same location.
Mhm.
That insulation can be moved around very readily. The code does not address a maintenance item.
I can assure you all, I don't get them in the roof.
And I would just add respectfully that I didn't call number 11, I didn't say whether it was or was not a violation. I just said,
Mr. Turlock is listening, it's not a violation.
okay.
And can someone show me where this says it does not require bracing? I didn't put up many trusses in my construction period of time, but all trusses I ever put up, if it was a gable-end roof, the manufacturer required diagonal bracing because it can rack. And so somewhere, this was handed to me saying that it's not required, but I didn't read the whole thing, but I don't see any place on there that says it is or is not required.
The requirement is shown, if it is required, by a 2x4 block with an X through it, showing where it needs to be placed. It also further states down in the information that if it is sheathed on the underside and the upper side by either sheetrock or plywood, it's not required.
But this is only a roof sheathing, there's no under sheathing there.
That is, yes. That is
It's
the
only
garage.
one sheathing on top, so it can rack.
It's got a drywall surface down below.
On the ceiling, yes.
Yes.
That has nothing to do with racking the trusses.
Those are the only two requirements that the manufacturer requires.
Well, all I'm saying is, all that I ever put up, it was a requirement. Where you have a gable end roof, a hip roof not required because that braces itself. All gable end trusses that I ever put up require diagonal bracing across both ends.
Mr. Bean, if you could help me see where you just cited that it says that it's sheet.
It should be the footnote over on the right-hand side, I think, the second one down.
I'm particularly looking at the open,
Right above the seal, right underneath the truss.
It's under bracing, right here, bracing. Sheath and gravel. Under bracing, cord, sheath, bottom cord. I can't read it, I can't see it.
so that last sentence, then since we're in that topic, I might dig in on this one. In accordance with the stabilizer installation guide, which,
That's an installation guide, that is not a final guide, it's the installation guide. During installation, correct bracing is required so that it does not rack. It's not required after the fact.
so this is BCSI, Guide to Good Practice for Handling, Installing, Restraining, and Bracing a Metal Plate Connected with Trusses. Page 38 says, trusses require permanent bracing within all the following planes: top chord plane, bottom chord plane, and web member plane. Doesn't say.
Unless it's designed. And the sheet that you have is the design document. And the sheet that's there also says, be good as far as the installation of it, not the permanent installation. I will let you know that, again, during my 35 to 40 years with the construction, the truss manufacturer will tell you, you can put that in if you'd like to, but it's not required. Our trusses are designed for that load, as long as you do the sheathing on the ceiling and some type of structural member on the bottom of the truss.
So you think Juan Garcia would be,
I'm sorry.
I'm just referring to the PE, he would be, obviously,
Yes.
the permanent sheathing would be adequate for lateral bracing.
Point of order? Point of order?
Okay. We're in discussion, so.
Are we in discussion or questions? Are we in discussion or questions?
But
Okay.
that's the way I see it.
Okay.
I have something to clarify this, if I was about to.
Just a minute, please.
I'm done.
Okay. No?
Yeah.
Okay. Go ahead. Last time,
Huh?
last time.
Well, I'm a property owner, so I'm entitled to do this too.
I got you. You can do your own.
Per the USBC, you have to have approved construction documents. The truss documents that you have were never given to Mr. Beam to be approved construction documents as they should have. My original contract called for all hand-cut roof system, so I'm not sure why trusses were used. But in our last appeal meeting, we did address this, that the truss specs were not part of the approved construction documents. They were never given to Mr. Beam. He did not have a permanent copy here in the building. And for the contract, it was all supposed to be hand cut. So the use of trusses were never approved by him in the first place.
Plan did call for roof rafters, not trusses.
But for me, that's a contractual issue. It's not.
The hand cut part of the roof was the main body of the house, because the original plan had a cathedral ceiling, and Ms. Atwood asked to have that enclosed so that she had more living space on the second floor. There was no reason to do hand-cut trusses on the garage. Factory trusses with an engineer design were fine, but this
It was said that's not a code violation. That was between the contractor and the owner.
I mean, typically, most of it, all the time, is truss design does not have to be on plan review, but it has to be on site for framing inspection. That's in almost every county. But they don't require, none of the counties require it up front. They require it to be at framing inspection. So I can't tell you whether they were there or not, but that's when they typically do not have to be provided to the municipality. They just have to be provided on the job site. Do we have any other discussion?
Well,
You want to close it one?
Close the meeting for the board and stuff.
First, then we'll discuss.
What are our options here? We'll have to close it to discuss that, I guess. Wouldn't we?
Yeah.
If that's it, anybody, one more time. All right, we'll close the public hearing. We'll go into discussion.
I guess make a motion that we close the meeting to open public discussion and have discussion of the board.
I'll say.
All in favor?
Aye.
All opposed? Okay. We are in discussion.
so what are our options? Reverse ourselves? Refuse to reverse ourselves?
It's the most difficult one I've ever been involved in my entire life.
Well, from the very beginning, a strange bird.
I mean, with the information given, you can't.
TRB's involved. And the TRB is going to be involved. So what our opinions are.
We didn't cite them code violations.
Well, let me ask you a question.
That's just
Do
my.
I-
Yeah, well, that's what I concur that at that meeting, along with my list, I should have cited these items, which are the code sections and pertain to those. So at that point, the appellant had nothing to go against, so I would accept responsibility for not attaching the code sections I felt were, so my personal opinion is to forge ahead and use Mr. Beam's list and maintain that list. And all the ones that we did, items 2, 5, 8, 9, 2, 5, 8, 9, and 11 of the current list, based on the technicality that we did not give the appellant the opportunity to know what code he violated. And so moved.
Mr. Hatcher?
What are you saying, that we rescind those items?
Again, given, regrettably, we learned about our errors in the Northern Virginia Daily, but the not attaching a code reference to it did not give the appellant the opportunity to even know what they're being cited for. So, even though I may or may not have an opinion one way or the other on that, I think from the standpoint of what this board should do, I would concur we're not supposed to be originating. So that combined with no code item,
What
I don't know,
items,
we could
which items are you saying?
items 2, 5, 8, 9, and 11 on this list. He gave us the list with the numbers.
Well, I think two is not the hangers themselves, but the fasteners, and I visually can't see any fasteners in those trusses, floor trusses. There's a hanger there, but I don't see any fasteners.
They're top now.
They're
top now.
No, but that's on the supporting truss, not on the truss here.
No, this hanging is the top now. It goes
Yeah,
up and
nailed
over.
up here,
It goes up and over.
but it's not nailed to this truss.
It hangs, they just have it designed to hang in.
I understand that, but supposedly it's got holes there, but fasteners.
There are no holes in it.
That one I actually would disagree. I concur with what George was saying, that we just can't see the nails. But based on discussions I've
But
had,
there is holes in the flange of that.
No,
What's that right there? Is that not a hole?
they're an Angeles truss hanger.
Okay, so we're saying item 2, 5, because that joist can be supported, it doesn't have a head.
Yeah, it can be set on something, but we
Right.
can't
It
see
has-
it. You can't see it set.
It's not a sitting on.
Yes.
Okay, so 2, 5. I have a hard time with number 7 because
That's
I don't know who put their body against it and said it was 200 pounds, but that is not a way to put up a post. And I have a hard time believing that the steps are not part of the porch. Number 10, we don't know who caused that, so I agree with that. So we're saying, let me just try it again. 2,
5,
5,
8,
10, 9,
yes, and 11.
10, and 11?
No, just 11 on that page.
But it doesn't have 2-inch clearance. That's required. Mr. Bean just said so. The 2-inch minimum required is required. Even with insulation. Wood and insulation. 11 has to stay.
Under which code section?
I don't know, but I've seen it somewhere. It's always been required, 2-inch minimum. Masonry chimney, prefab chimney, and insulation. Mr. Bean just, a while ago, said it was required. required.
There's there's guidance in R 1003.19, talking about fire blocking.
That's fire blocking something different.
Right, I understand.
I've always seen a requirement for facing around a chimney, whether it's masonry, prefab, or insulation. And Mr. Beam himself just stated a while ago that was required. Am I not right, Mr. Beam?
We're in discussion, Mr.
Well,
I'm sorry.
Everything I can
Anyway,
find related in the code related to masonry.
huh?
Everything I can find in code related to masonry. It's cited UL 103 or 127.
I can go along with that, and I'll go along with the rest of it. That is a requirement. I'm okay with 2, 5, and 8, 9.
I
10.
kind of have a question on 3. With you guys, is that was done after the fact. Number 3 was done after final inspection.
So,
I'm just throwing it out there, I'm just saying it was done after the fact. I mean,
by the builder or by the owner?
I can't answer that, I don't know, I just was told it was done after the fact. But we just heard it was done.
I don't do carpentry. I can tell you that.
Number 3 was done after.
What,
Oh, the roof wasn't put
because
up
if
there.
you look at, I mean, if it is number 3, it's, the work was completed after the final inspection.
Just said it was completed.
After the final inspection, it was not part of the approval process.
But if it's, I mean, rather than say that anything done after inspection is okay, if it doesn't meet code, and that's how we're going
I
to
don't think so.
swallow.
I'm just saying, I can't ask who did it.
It should have been, the inspector should have gone back.
Well, but if you
Well, how
don't
would
know,
you, how would you?
Yeah,
if you don't know,
but it's still there, it's still part of the construction.
Correct. Yes.
And it's still done by the contractor. I'm good for it. 2, 5, 8, 9, 10.
I do understand 7, because it's within 30 inches of the ground. So theoretically, the rail that's there is a cosmetic issue. It's not a supportive issue, because the deck's within 30 inches. It's within the deck.
So you're saying
You don't need
you
the
would have
rail.
had to have
You
the
don't
rating,
even need,
period.
you don't need the
I
rail.
agree with that, because it says it's the same thing as rating going down the steps.
So it becomes decorative.
But it's there. So it has to meet, if it's put there, it's gonna have to meet the requirements. If it's put there. 'Cause
Hence
you
the
get,
functionality.
you get maybe a bunch of drunk people out on the deck and decide to lean against, sorry. The post,
Yeah, no, that's my opinion. I don't know that necessarily is the interpretation, but I concur with there. That's the whole.
This is what you were sending?
Yeah.
Well, the trust bracelet's an issue.
I agree.
Clarify that, it doesn't.
Talk to Dr. Wesley of Virginia Tech, it does, so.
I mean, all my trust drawings, they actually show the placement of the two before, if it needs it. If it doesn't, there is none. And it usually says the top sheet or the under sheet can be used as bracing. I'm just telling you what I said.
Right,
What
no.
I did.
I understand.
I mean, if the writing one's so small, I could probably read this. Top quote says she prefers. Rigid seal or bracing, 10 for center, which usually means 10. Usually just, when it does that, if I'm going to put a finger, it's one here, one there, 10. But typically, everything does like this, shakes.
Right, right, no, I understand. Typically, actually,
So, we could call them on and ask them.
you ready for a motion?
Yeah.
Okay. Then I'd like to introduce a motion that we support the code official's decision on items 3, 4, 6, 7, 10, and 12. And rescind the statements that were made in the last meeting for the others.
Rescinding which one?
Yeah.
Motion should relate to what you're appointing in the appeal versus you can go back to the
Yeah, I
last.
understand. Okay, so. One more time. The motion is that we are accepting as code violations items 3, 4, 6, 7, 10, and 12 of this list.
3, 4, 7.
3, 4, 6, 7, 10, 12.
What about number 1?
You're supporting those, and you're
Yes.
rescinding the others.
So we can't do that, but we're supporting these, so for this appeal.
You're supporting as code violations.
Yes, sir.
Just want to make sure.
But we're voting.
Yeah, what I'm voting on.
So basically, you're denying, your motion to deny 3, 4,
11 has to be included plus.
Okay. To say it one more time?
We're denying it.
If I'm understanding, you're denying the appeal on, or you're making a motion to deny the appeal on 3, 4, 6, 7, 10, and 12.
Yes. Thank you for the clarification.
Do we have a second?
One second.
All in favor, signify by saying aye.
Aye.
All opposed?
No. Got that left.
I guess that ends the discussion part of it. Any old business?
Hold on.
Any new business? Motion to adjourn the meeting.
I make a motion to adjourn the meeting.
Second.
Aye. George.
Any here?
Right, meeting adjourned.